Hi, guys. It's Kathy. I hope you're doing well. Okay. So we got a new feature, it looks like community leaderboard and experience points. So, from what I see, what is a leaderboard? A place for fans to stand out in the community. The top 3 get special badges in live chat. It resets every stream, so you can always try again. How do you get on the leaderboard? You need to collect experience points, or XP. Here's how you get them. Send live chat messages, send super chats, and super stickers. So now we know. I'm just messing around. So the numbers will probably change all through chat. That's cool. I like it. I want to go in a whole bunch of chat rooms and try to stay steady at number 3. Win, place, or show. I'll take show every day. All right. I'm actually not done yet. Judge Juanita is still exporting, but that's okay because I have something else to do. That Florida guy. Let's start with him. Let me share my screen. Hi, Nicole. All right. I'm going to make sure that it's unmuted. There we go. Let's go to this Florida guy.
Siéntese.
Be approved.
Hey, Mr. Biggs.
Good morning.
Good afternoon. Mr. Biggs, you are here with us based on an allegation that you missed court with Judge Wilson on February 18th, 2025. Unfortunately, Judge Wilson issued no bond. You're going to remain on no bond until you can get in front of her and let her know what's going on. I will appoint the Office of the Public Defender to represent your interests. Does he have any court dates?
Next,
May I speak, please? I apologize.
Hey, I'll give you a chance in just a minute. Let me announce your court dates.
next court date, March 4th, 8:45 a.m., courtroom 5F.
All right, you've got a court date already with Judge Wilson. I've appointed an attorney. Be a good idea to run whatever you want to put on the record by her first, but I'm happy to hear you out.
So I called beforehand and said I was going to be 30 minutes late for court. They said, okay, I showed up, but she took me to jail. I'm confused on how I'm not eligible for a bond if I shouldn't even really be here right now. I called beforehand.
I don't know who you called, and I don't have any information about.
Y'all can check. I apologize for disrupting you, but y'all can check, Your Honor.
Well, you're saying y'all. I didn't issue the warrant. Judge Wilson issued a warrant for you. I'm assuming she had the best information that anybody had when she issued it. I've appointed an attorney. They can get you in front of Judge Wilson. If there's some misunderstanding, they can get you in front pretty quick. But I'm not going to reverse her decision because I don't know a thing about what happened. So.
Okay, so basically you can't reverse her decision. Basically, I just have to wait for her. Basically.
Well, I could, but I don't have any information to do that. So you're telling me that you called somebody and I don't have that information in front of me. The state gets an opportunity to weigh in on that decision as well. Your attorney can file a motion that lets everybody know what the issue is so we can take a look at it. So for today's purposes, I'm not going to reverse her decision, and your attorney can get you in front of Judge Wilson pretty quick. Thanks.
Y'all weird as fuck. Confused on how, where's the human at? Like, I showed up to court, boss man. I never missed court. I've been on time.
Mr. Biggs, you were treated courteously. I heard you out. I let you speak. I got rewarded with a bunch of F words. So
I didn't cuss you out. I never cussed you out, Your Honor. Never cussed you out, Your Honor. Never would disrespect you like that.
All right. All right. It's going to go a lot better with Judge Wilson if you keep your cool and just let her know what's going on and talk to your attorney. All right.
Yes, sir.
See you, Mr. Biggs.
You have a good day.
You as well. State of Florida versus Michael Dainty.
Florida never disappoints. You know that? So I went out after work and I got home like 2 hours ago. And Florida never disappoints. It was just there for me, waiting. Oh, man. Don't cuss out the judge. I mean, what didn't your mama teach you that? Okay. This one's next.
Born and raised here in Harvestville, Your Honor. Attended high school here. He's a father of 10 children, Your Honor.
He's a father of 10 children. 10 children.
I do want to note that his father is here present with him. Mr. Clark has 2 children that are graduating from high school this year. And he also had one that graduated from college last year and one that graduated from high school also graduated from high school last year. Your Honor, you know, we just came upon what we call the redemption season that we just came out of. And in this situation, Your Honor, I would like the court to kind of hear me out on Mr. Clark and his road, okay? He's made some mistakes. He's made some mistakes in his life. There's no doubt about that. However, Your Honor, at the time of this situation that happened in Jones County, he was actually working 2 jobs. He was working at Amazon and also at Bluebird. And just a little factual background about what transpired. I think it would give the court a little more clearer context. Mr. Clark was driving someone else's car, Miss Williams. He was driving her car, and there was a flock hit on the vehicle because there was no insurance, unbeknownst to Mr. Clark. Gets pulled over by the Jones County Sheriff Department, and in that there was a situation that had occurred here in Pulaski County that said it was a warrant outstanding for his arrest, which was kind of confusing to him. However, there was a warrant, and that's what precipitated a lot of the search of the vehicle. In the search of the vehicle, there was a weapon found. Mr. Clark is, at the time, was and still is a convicted felon, Your Honor. And there was a weapon found in the vehicle. And also on Mr. Clark's person, there was a small, roughly about 1.5 or 6 grams of methamphetamine, a pill. And as a result of that, of course, all that happened in Jones County. And I didn't represent him at the prelim, but I did represent him later on. And we ended up getting this matter resolved in Jones County. He did plead guilty. And the reason why he pled guilty, Your Honor, especially to the possession of firearm charge, is because ideally, even though it wasn't his vehicle, and I've already showed it to Mr. Pritchett, the owner of the vehicle, Ms. Williams, testified at a Camille hearing 2 things. One, that the vehicle was hers, and also she testified that the weapon belonged to her. But the problem was it was in arm's reach, which was in the center console of the vehicle, okay? And so as a result of that, as I explained to Mr. Clark during our colloquy, is that he is kind of constructively possesses everything that's in that vehicle, even though it's not his. But the fact that it was in arm reach, and they asked him about the firearm, does he have anything in the car? And basically, he said, yeah, I just talked to her. She had left the weapon because he had called her on the phone, asked about the insurance situation while he was on the side of the road, and basically let her know about the weapon that was in the car. And I do, and I've already showed it to Mr. Pritchett. There was a direct examination. If I can approach you, Your Honor, if you mind approaching, and just show you, I had this transcribed. This was a preliminary hearing where Miss Williams, and you can start page here, 29, and starting at 21. That's what she makes the admission.
All right. You want this back, Mr. Hurd? Yes, sir.
Your Honor. So, and unfortunately for Mr. Clark, like I said, the weapon was in the vehicle. He had on his person, he had in his pocket, he did have some pill methamphetamine, which was 1.2 grams that it tested out to, weighted out to.
Thank you, Chris.
I've already showed this to Mr. Pritchett. May I approach your Honor?
You may. Okay.
Your Honor, Mr. Clark has had a drug issue, substance abuse problem, for quite a while. And Your Honor, that's never been really adequately addressed. We're asking in here that Mr. Clark be sentenced to time served since March 14th, 2024, return back to probation. His father and his family has the ability to catch him up and pay off the fines that are owed on the case, Your Honor. He's gotten his GED, Your Honor, and his ambition is to get his CDLs, and he's definitely working toward those because obviously him working 2 jobs, CDL will definitely provide him a better lifestyle for him and his children. He wants to be president.
With the CDL, he'll have a truck big enough to carry all his kids, grandkids, and all the weapons he wants.
He wants to be president during graduation that are coming up. Like I said, this road to redemption, we just came out of redemption season. And, we're asking the court to show some mercy and give Mr. Clark a chance to do the things that are necessary. One is address his drug problem, because no matter what happens, he goes into the facility these years that they're recommending, still gonna have to deal with the drug issue, Your Honor. He's willing to do a substance abuse outpatient program, Your Honor, that the court may require, any other conditions that the court may and additionally levy upon him. And let me use the back. I was hired by his brother who lives in South Carolina. And of course, his brother is his younger brother who really wants him to come live there because to kind of get away from the elements. Sometimes that seems to sometimes entice and entangle him. But ideally, it's a brother that loves him, that's done a lot for him, just like his mom, his father.
Donald, thank you so much. Thank you.
Our mother's actually worked at this present moment, and she couldn't be here, Your Honor. He wants to be present in his children's life. He understands that he is the master of his fate, Your Honor. He's made some decisions. Yes, he has made some bad decisions, Your Honor. But in this situation, I think that as a result of him being in jail since March 14, 2024, has sent a direct message to him, a strong message to him about getting his life together. And Your Honor, he's made substantial moves in that direction. I had the opportunity to go down and speak with him last week, and in that conversation, as I was walking to meet with him, all the jailers were commenting on just the type of person that he was, and how he's there to help everybody, put him on trustee duty, just doing things not for no grandiose. He's doing it just because that's who he is. But unfortunately, he's made some bad decisions, and I just don't want this to stranglehold him for the rest of his life. And there's some things he needs to make amends to, and one is his drug substance abuse issue, but also with his children and his family. Your Honor, we're requesting that he receive time served, get back on the remaining part of this probation, allow him to get back his life together, allow him to be a benefit in a institution within his children's lives, also allow him to serve this community in a better capacity that he served this community before in the past.
All right, thank you, Mr. Hurd. You can stay where you're at. Mr. Pritchett, go ahead.
Yes, Your Honor. Of course, council's asking for redemption or a second chance for Mr. Clark, and I appreciate he's got a job to do. Of course, Your Honor, he was already given that second chance. He got put on probation and got an aggravated assault, which could have been a 20-year prison sentence in the first place, and got a 10-year probation sentence with the options of being able to terminate early. And he was banished from the circuit, but he was going to be able to terminate early after 6 years. Your Honor, we believe anybody that's a convicted felon who then gets another charge, convicted felon while they're out on probation, needs to go to prison, and that's the bottom line. We believe that would be fair. I mean,
CJ, I hope you had good news today.
the case is not contested that he admitted to it. There's some statements or whatever in this, committal hearing to the effect that this person, other person owned the gun, owned the car, whatever. To me, that's ownership is not the issue of possession. Obviously, we're dealing with possession, and he was in possession. He's admitted possession. He's admitted possession of the drugs. He shouldn't have the drugs either. He had the opportunity to get treatment for drugs before now, but he was out there with drugs, and so and of course, there's opportunity for treatment for drugs in the prison system. If the court's inclined to somewhere do something different than what the state recommended a prison time, we did agree that it would be a cap plea at 5 years in prison. And that would be the most the court could take. Of course, we were agreeable with a termination of the balance if the court were to revoke the 5 years. We've also indicated to council that as part of our recommendation, if there's a mission today, and I don't think it's been put on record yet, is that the new charges out of Pulaski County, which are really new old charges. It's been a while since the warrant's been out there a while. They had not been served on him for a situation about a conspiracy related to a cell phone going into the jail with the previous administration, that we would dismiss that charge as part of this admission today. So that is part of what's going on there as well, Your Honor. But we would submit to the court that he's had an opportunity to be put on probation. He's gotten in trouble over there in Jones County, and now he's going to have to, deal with the court about that. And so we believe that we're not being over punitive by asking him to be sent to prison. Now, there is an initial suspended order, I believe, in the my reading of it is the court's inclined to do something different than enact the RSAT and make him go to RSAT to get that drug treatment that they're saying he needs. But we think prison would be appropriate in this case, Your Honor. We'd ask you to revoke that up to 5 years. We're asking for 5, but if the court feels like something less, and that's fine. And we're not obviously opposed to him getting credit for time served for the year and some change that he's been in since there's been a probation hold on him ever since the time of these new offenses in Jones County. But he is convicted out of the Superior Court in Jones County on these new charges he's admitted to.
I do want to just say one last thing, Your Honor.
Sure.
Mr. Clark, in that resolution to the Jones County case, he has remained, I think about 7 years on probation.
I got this while I was at work. And while I was at work during the day, Bill goes live. And of course, if you don't have all notifications on for American courts, you need to go right now and make sure that all notifications are on so that you know when he goes live, or she, I should say. Anyway, speaking of that, if you're watching this, just check and make sure you're still subscribed to my channel if you would like to be, because a lot of people were unsubscribed, and you can fix that by just subscribing again.
So it won't be a situation where he will not be supervised, Your Honor. And I believe because he lives here in Hawkinsville, it will probably end up being Pulaski County will definitely be the supervising county for his probation, Your Honor. So there's definitely a catch-all somewhere. But however, we ask that this matter be time served here and that he be restored back to coming back to.
He's banished from the circuit, it looks like to me, Your Honor, from the original sentence.
So I don't know how that's going to work.
I don't think he's supposed to be coming back here. So.
YouTube randomly unsubscribes people all the time. It's very frustrating.
Unless it's related to his daughter, an event related to his daughter.
everybody seems to like you. You've just bad decisions, I think is what he said. But I do give you the chance to address the court. Apparently you've resolved the cases in Jones County.
Yes, Your Honor.
There's nothing you cannot hurt yourself at this point. So first of all, let me ask you, Mr. Clark, do you have any questions about anything that's happened up to this point?
No,
Or anything you'd like to say?
Yes, sir.
Go ahead.
The charges that I got put on probation for.
Here? Yes, sir.
Yes, sir. I know I pleaded guilty to it, but I really wasn't guilty for it. But I took the charges because I sat in the county.
That horse left the barn a long time ago, Mr. Clark. I can't change that.
I show this judge all the time. You can only see this judge on my channel. You're not going to see him anywhere else. I don't know his name. Maybe one day we'll get his name, but I don't know what his name is.
But from this point forward, I want to get out and be with my kids. I know I have messed up in the past.
Yeah.
And I'm 44. I'll be 45 this year. And I want to be around my kids.
Well, I understand that, Mr. Clark, but you haven't been for over a year. You were in Jones County and you've been in Pulaski since how long?
February.
Since then? Oh, okay.
February.
Oh, February. Okay. When did you resolve the Jones County case?
It's like January the 2nd when the sentence was filed.
Oh, okay. So you came here
This
right
year.
after that. I got you. Well, Mr. Clark, these are tough. I mean, I take no pleasure in any of these. They're hard. It's difficult. I don't know what's right. I don't know what's wrong. I just get paid to make decisions, Mr. Clark, and it's not up to me I'll let somebody else figure out whether it's right or whether it's wrong. But I want you to understand a couple of things, Mr. Clark. I am not saying you're a bad person. Mr. Hurd has done a good job of convincing me that you seem to be a conscientious young man. You just made a couple of bad decisions here. And I don't know about all this other stuff. That's not in front of me. All these other counts, they're not part of this situation today. I'm not even considering those. My sole function today is to determine whether
You stop reading my mind. As soon as you said that, I thought, oh God, I'm going to jail. I'm getting away from these kids and these cats. The only they would let me take my dog in jail with me. It would be perfect.
you have any possibility of succeeding on probation anymore. That's it. If the court finds you're not a suitable candidate for probation any longer, then that's one decision. The other one is, as Mr. Pritchett stated, if the court is inclined to think there is some chance of getting you successfully through the balance of your probation, then the court's got all sorts of options to RSAT. But RSAT, you won't go home either. If you've got a drug problem, Mr. Clark, we're just kind of kicking the can down the road. If that's and truly the situation. And
I'm not saying he is, but some people do drugs but are a criminal. So even if the drugs weren't involved at all, they would still be a criminal. And it's not drugs that are making them do the crime. It's because they're a criminal.
RSAT is, I don't know if you talked to Mr. Hurd about RSAT, but some people love RSAT and some people say it's the worst thing ever. I don't know. But I can tell you one thing for sure, it's confinement. You can't just walk out the door. You won't be home.
And that's why we ask for outpatient, because I think outpatient does a better job of addressing these situations.
And there's options that the court can do for the, if you're not on confinement, other things. All right, so you're banned from the Oconee Judicial Circuit in Pulaski County. You were living in Jones County, is that correct?
No, sir.
Where were you living?
I was staying in Atlanta.
Here?
No, in Atlanta.
Oh, in Atlanta. Oh, I got you. Well, what it comes down to is the court's got to decide whether to keep you on probation or just clean all this up and wind it up. And Mr. Clark, as difficult as it is, I'm going to make some hard decisions here that just come with the job. It's not easy to make these kind of cases, make these decisions in these kind of cases. But unfortunately, I have reached the conclusion that probation just doesn't seem to be working. And I don't see any point in putting it off. Now I'm going to craft something here that is not exactly what the state has. Well, Mr. Pritchett kind of said something along the lines of apparently the DA's office is not trying to revoke your entire balance, which is what, six years or so. I mean,
Yes, sir.
I don't think that would accomplish anything. And everybody in this room knows as soon as you walk out of here that you're subject to the jurisdiction of another state agency, not me. And I have absolutely no idea what that other state agency may or may not do with your case. But I'm going to come up with something that's kind of in the middle that won't be quite so punitive, Mr. Clark, but unfortunately, I am going to, for you, I am going to revoke 3
I love
years,
Judge
but I'm
McBurney.
going to give you credit back to whatever the date is.
March 14th.
Hold on, let me write that down.
Is that correct, Mr. Pritchett?
That's correct.
That's 2024.
Yes, Your Honor.
Yes, Your Honor.
So you'll get credit for every minute of that time, Mr. Clark. And I'm sure Mr. Hurd has gone over how this works with you with parole, pardon and parole. I don't have a clue what they're going to do. Who knows? It's a crapshoot. I don't see anything violent in your record, Mr. Clark. So what I'm trying to tell you, Mr. Clark, is you got a reasonable chance of getting this behind you. And I'm going to terminate the balance, which means you won't be on probation when you get out. I just don't see any point of it. And you'll get that chance. It's just not exactly the way you expected. All right.
And Your Honor, let's make sure that he's aware that he does have whatever balance he has.
What do you mean he's not getting it the way he expected it? He wasn't expecting to go back to jail? I think he was, because remember, Judge, don't you remember when you put him on probation? You told him that if he violated probation, that you were going to revoke the remainder of his sentence. And he was going to go back to prison, actually. He was going to go back to prison. So he knew this was coming because he broke 4 times. He broke probation, committed 4 crimes. Now, one of those crimes is the violation of probation. So, you know what? I'll give him that. He only committed 3 actual crimes. Only 1 or 2 of them here. The rest are completely in another state. You don't even have to worry about that. But that's why he only gave him 3 years, guys, by the way. He was supposed to get his 6 years revoked and go back to DOC for 6 years. But while he was out on probation, he committed more crimes in other states. Now they all want to put him in jail. So this judge is like, okay, we'll give him 3 years, and then the other people can give him whatever they want to. All right. Let's see if Juanita is ready. So, I promise you that she is getting her audio fixed. I've texted her. She's texted me. She's listened to her own court, and she says it's not okay. And she is getting her audio fixed. But I love Judge Juanita Jackson, and I can't wait for her to get her audio fixed. Now, she had a trial yesterday and today, and we're not going to watch the whole trial or even any part of the trial. All we're going to do is watch the closing statements and the verdict. That's it. Just so we can see a little bit of Judge Juanita today. It'll make our day go much better. All right, so I did 2 things to try to help you guys. And hopefully it worked. I don't know. Sandra, happy birthday. Oh, I'm so excited for you. Okay. I did 2 instructions today. Instructions. CJ, I did 2 things for you. I tried to bump the volume up loud so we can hear. It's very hard to hear. And I tried to add closed captions. The only problem is I had like 10 minutes to do that. I was still doing that when 4:35 hit. And during the first video, I was still doing that. So I didn't get a chance to double check the closed captions to make sure they're even close to right. So we're just going to roll with it. All right. We're just going to use closed captions as context clues to figure out what they're actually saying. Here's what I know. 2 Karens and 1 very, very, very frustrated man. The man is on the hook right now because the 2 Karens got in his face, and guess what? He slapped one of them twice. So he's on the stand right now for assault or battery or assault and battery, or I don't know. And the 2 Karens, I don't think so. I think, but I'm not sure. And if I remember from what I heard, sort of like I'm doing other things while I'm recording. So sometimes I can hear things, sometimes I can't. What I think is the 2 women, they're in a relationship. And he is related to one of them, like a cousin. And that's the person he slapped twice because she was threatening him and calling him all kinds of names up in his face and screaming at him. And even when she called the police, she was screaming hysterically. And he's saying on this 911 call, "Stop hitting me. Stop hitting me." But we're going to hear the closing statements. And then the jury's going to go deliberate. And then we're going to hear the verdict. That's all we're going to hear. I will get full trials or whatever as soon as she fixes her microphone. But until then, And that's right, Michael. If you love getting slapped, is it assault? Is slapping someone an assault? Who knows? I think it depends on the context. I don't think slapping someone's is an assault if, like, that's what they want you to do. I don't know. Let's see.
Okay. So let's just walk through kind of what Judge was kind of talking about, so a lot of kind of information. So this kind of looking at the basic elements of what my burden is in this case. So first in Harris County, Texas, that's kind of a, retired Judge Jackson kind of said that's kind of easier to prove. So we heard the officer testify, it was Harris County, controls that area. This was in Houston. And then the next element there is the defendant, Trayvon Davis. The officer testified about getting a call, and then with Cindy here, she testified about Mr. Davis, and it was him, and she identified also the line through the 911 call that it was him, and so that element's met. And then on or about March 12, 2024, we heard both sides testify about that. So the real meat of this is unlawfully intentional. And so the jury charge breaks it down into 2 main elements here. And so the first element is the defendant, Trayvon Davis, in Harris County, Texas, on or about March 12, 2024, caused bodily injury to SP by striking SP in the face, causing pain. So first of all, I know it's a SP city computer. That's why I'm here. Here it is a city computer. And so bodily injury, and we kind of walked through this in what is bodily, right? So we get a definition, and the definition says bodily injury means physical pain, illness, or impairment of physical condition. And we heard Ms. Keir testify that when she was slapped in the face, her adrenaline was brought down, and she finally felt her injuries. She testified that it hurt to move her jaw for about 2 weeks, and she felt pain, and even hearing a popping sound in her ear when she got struck. And so all those kind of things, that kind of all goes into bodily injury. That's pain. We can all agree that pain we felt long after as well. And so those 2 weeks of pain is from being struck. And so then also going into another definition or a part of element is the defendant did this, either intending to cause the pain to SP against Cindy Keir, or knowing that the injury to Cindy Keir would be caused. And we heard testimony from Ms. Keir that the defendant would hold his hand, struck her with his hand, and not only once, but he struck her twice. And so, once, I don't know, they might argue, oh, that was an accident. But twice, he knew what he was doing. That was not an accident. That was intentional. Pulling the hand back and striking again, pulling it back again and striking again. That's 2 times that he struck her. And so, intentionally and knowingly is met here. Ms. Keir testified about that. Again, bodily injury, that's the injury that Ms. Keir suffered. That's her testimony, feeling her face hurt. And then the defendant striking competitive defense testified about striking her palm, her backhand. Again, that's what his hand. I also want to remind the jury about the one witness rule that we talked about earlier, and how we all agree that one witness is enough to prove the case if you believe that witness beyond reasonable doubt and that they met all the elements beyond reasonable doubt. Here we have all those elements met by her beyond reasonable doubt. So let's also then go through self-defense. I know the defendant got up on the stand. I know he testified about being jumped by Alana and the claim of self-defense there. So the claim of self-defense, you need more than verbal provocation. And again, that's going to be in the jury charge. And that's going to be under relevant statutes of self-defense here. And so it says that self-defense does not cover conduct in response to verbal provocation alone. The defendant must have reasonably believed the other person done more than verbally provoke the defendant. So we need more than just verbal provocation. We need more. And we just don't have it. We don't have more. We don't have self-defense here. We heard Ms. Keir testify that she was trying to pull them apart, trying to stop the defendant from hurting her partner, and she was afraid. And then that's when the defendant's right. That's not self-defense. In fact, Ms. Keir is trying to defend her partner. And that's what she's twice. Let's then go into applying self-defense, just kind of the application of it. With self-defense, the defendant, Travion Davis, did not believe his conduct was, well, to find beyond reasonable doubt that neither the defendant, Travion Davis, did not believe his conduct was immediately necessary to protect himself against SP against any Keir's use or attempted use of unlawful force, or the defendant was not reasonable. So again, Cindy, your prime protector partner, there's no situation here where the defense believed that it was reasonably necessary to protect himself when she was pulling them apart. That is not something. And so to wrap this up briefly, with both of these elements, so self-defense elements, and then also the elements defined beyond reasonable doubt on page 5. So with the defendant did this either intending to cause injury to SP or no injury to SP will be caused. You don't have to agree on which one is met there. So you just all have to agree that element is met, number 2, but there's 2 elements. So you must all agree the state proves it beyond reasonable doubt, but you don't have to agree that 2A should be whichever one. So 3 of you could be 2A, 3 of you could be, and that's still beyond reasonable doubt, and that's still guilty. And then the same goes for self-defense. You don't have to believe that on which elements of these self-defense is met. So you don't have to agree that he did not believe this conduct was immediately necessary to protect himself against SP's use or attempted use of lawful force. And then the other 3 could agree that the defense belief was not reasonable. It was not reasonable in this situation to believe that it was necessary. And that's still a guilty verdict. And so based on all of these elements that we have here, Harris County, Texas, defendant, on or about March 12th, those are the easy 3. Did unlawfully, intentionally, knowingly cause bodily injury to SP. Those 2 elements right there on that, just by the testimony of Sydney Pierre, that he intentionally and unlawfully struck her with his hand, and she testified that caused her bodily injury. 2 weeks of pain. And I'm sure when you go back to the jury room and deliberate, and you look at all these elements, and you consider all the things, and the testimony that we had, that the verdict will be the only verdict you can reach, and that is guilty.
Ms. Lyman, you may proceed. Thank you, Judge. Good morning, everyone. Thank you for your attention in this case. So when you go into the back, you're going to have the charge with you. There's a lot of them. As you read through that again, and when you have the judge read it, it's talking about its own. Well, really, I just want to look at the evidence in this case. The state has the burden of proof. We talked about burden of proof and how high that burden is a lot during board on. I just want you to look at the evidence or lack of evidence in this case. Ms. Pierre testified that she was hit by my client twice and that her jaw hurt so badly for 2 weeks afterward that it hurt to chew. If someone got hit that hard, there would be some sort of swelling, redness, something, where it hurt to chew for 2 weeks on a slap. I just think that she's exaggerating that. Miss Pierre, I do believe, got hurt, and she's angry about it, and she came in here and testified because she's upset that she was injured. I don't think she was injured near as badly as she's saying, and I don't think it happened how she said. I think she inserted herself into something that she should not have. She saw her girlfriend jump on him, and she jumped in to help. When he was defending himself against his cousin-in-law. There's no pictures of injury. You know she would have taken one had there been swelling. The Officer Trevio, that testified, She didn't testify that there was any redness or swelling or injury on her face. She testified that he got there within 10 minutes of the 911 call. So within 10 minutes of that happening, that it hurt you so badly that you couldn't chew without pain for 2 weeks. Sure seems like there would be some evidence of that injury. I also want you to listen to those 911s. I mean, when you first hear the 911s, your initial reaction is, oh my gosh, you know, what's happened? Because it is absolute, irate, out of control, screaming. Can't even understand a lot of what Alana is saying on that. What you can understand is you can hear her calling my client a bitch over and over, screaming at him to sit his ass down, that she's got something for him. She sounds like an aggressor. Ms. Pierre even testified that she was angry and aggressive. She said that about my client, but she also said it about her girlfriend. And on those 911s, I think it's very obvious who the aggressor is, who the out of control person is. She's rude to the 911 operator. And the only thing that my client can be heard saying is, don't touch me. If you listen to them, there's 2 of them. Just listen to them again. You start and stop them. I guess the biggest question or lack of evidence here, the big hole in this, is where is Alana? Where is his cousin that was assaulted, that saw Ms. Pierre being assaulted? Why isn't she here testifying that she was choked, that she was assaulted, that he attacked her first and her girlfriend, Ms. Pierre, was just defending her? Where is she? Why is only Ms. Pierre here? Mr. Davis testified that he was being assaulted by both of them before he ever did anything to them. Now, at some point he testifies that Alana is shaking her finger in his face, he's pushing her finger down, and I can picture this whole thing. How families fight or people get into it. And then she pushes his face like this, down his neck like that. And then that's when he pushes her, and Alana, I'm sorry, Miss Pierre jumps up off the bed and starts to defend her. He had the absolute right when they were both punching on his head and to push them off, to defend himself, to slap back at them. And I can only imagine this is all happening really fast. Everybody's screaming, yelling, obviously cussing at each other, and Alana gets hurt. She's upset about that. She blames him for that. I get that. But he's not guilty of assault. This was a situation of self-defense. This whole situation was a ridiculous fight between family members and a family member's girlfriend about cleaning up the house and paying bills. And we shouldn't be here today. He doesn't deserve to get convicted because the state has not proven their case beyond a reasonable doubt. There's a concerning lack of evidence. I also want to talk about Miss Pierre. They were talking, she kept saying over and over, well, that was before he fled the scene. That was when he fled the scene. Well, that was before, well, she called after he fled the scene. She must have said it 7 or 8 times. What would you have done? If you're in a fight and it makes sense that he would leave. I mean, 2 women he's just gotten in a physical altercation with. And they're screaming, and you can hear that screaming and yelling on the 911. You extricate yourself from the situation. It only makes sense. I ask that you find Mr. Davis not guilty, because the state is not met the burden. Thank you.
Mr. Hill, you were battle. Thank you, Joe. This case is about Sydney Pier. It's not about Lana. It's about Sydney Pier. So let's keep that memorized, because Sydney Pier was not the one that was getting in the initial fight with the defendant. She was the peacekeeper. She was trying to keep the peace in the house. She was trying to protect her girlfriend from a fight, and she was trying to protect the defendant from a fight as well. But the defendant did not have it. He would not accept that. And so what he did was he turned around and slapped her in the face. Again, this is not about a lie. I remember during her diary when Miss Leitner got up and she said, who would want to go on the stand? Who would want to open themselves up to a cross-examination and to spill your entire life, essentially, or at least this one day to a group of strangers? And I didn't see a single hand. No one wants to do that. But Sydney here got up there and she was willing to do that. Out of anger, as defenseless, out of a sense of justice. That's what this case is about. Because if you see right there, March 12th, 2024, that is over a year ago. And I find it hard to believe that Miss Pier held this grudge for a year and about 2 months. She's like, ooh, when my day comes, I will get him for slapping me that one time, a year and 2 months ago. But instead, she got up here and she told the truth to a group of 6 unknown strangers because she needed resolution. And again, one witness. We have one witness, Miss Pier, the person that intimately knows the facts of this case, because she was the one that was a part of this case. Also, listen to 911. There's a lot of anger. The defendant was also married. And he was yelling back. Miss Pier never said that Alana was broken. All she said is that she was trying to break a fight after she saw her girlfriend in the bush. And she got slapped. Sydney Pier ultimately got in the middle of the game. That's something we can all agree. But the defendant saying on the stand, never did. Never did. That was the mistake. Then the defendant, after this, fled the scene. He knows the police are being called. He knows one side of the story is going to be told. Why wouldn't he want his side told? Why wouldn't he want to vindicate himself from that? Why would he run away? Ultimately, looking at all these elements and listening to Ms. Pier, who selflessly got on the stand to just speak the truth. These elements are clearly met. And all we need is Ms. Pier to go up there, to have that one day of courage to go up there. And that's what we have. And so ultimately, based on all these elements, Ms. Pier has met them all. And the verdict must be, in the interest of justice, guilty.
Thank you. Okay, ladies and gentlemen of the jury, or ladies and gentlemen of the jury, all of the evidence, the charge of court, and the closing arguments are before you. Now I'm going to hand the bailiff the charge of the court and the law in this case. And now at this time, once you're all back in the room, you may formally begin your deliberation. And we are adjourned until a verdict is rendered.
All rise for the jury.
Everyone may be seated. We are back on the record for cause number 2508991. Let the record reflect that the attorney for the state and the attorneys for the defense and all the members of the jury are present. And have you all reached a verdict in this cause? Yes, Your Honor. Okay, presiding juror, would you hand the verdict sheet to the bailiff, please? In cause number 2508991, we, the jury, find the defendant, Travion DeAndre Davis, not guilty.
Not
That's
guilty.
the unanimous verdict of all members of the jury. Okay. Well, ladies and gentlemen, does anyone, are we all good? Any other matters? Now, at this time, ladies and gentlemen, your duty as jurors is now complete. And at the beginning of the trial, I gave you instructions and I told you that there was a number of instructions in that, especially about the part about secrecy. You are no longer under that order. You can now talk with anyone about your deliberations. And should you decide to discuss the case, that you could discuss it with either party. And you're free to discuss the case. As a matter of fact, I'm pretty certain that both the sides, the defense and the prosecution will want to talk to you, and I'll come back there and talk to you myself in a few minutes before you leave out. Now, you're not required to stay, but I would ideally ask you if you could remain just a few minutes so that both sides can talk to you. Would greatly appreciate it. So at this point, you are now excused. Thank you.
Well, there's our Judge Jackson. She's ours right now. I don't know if anybody else plays her, although because of the popularity of Judge Fleischer, they know where to find her. She used to be just mine. I think right now I'm the only one playing her. I'm not sure. I don't know. I think Bill likes to play her because she's so good. I can't wait till she fixes her audio. Then we can all watch her. But all right. So this next one, okay, that is all the time I had from the time I got home, 2 hours before the stream started until the stream started. But I have this. I have 2 back pocket ideas, and I'm hoping it works. If I try to get ones that are too current, you guys can't hear them. Well, 50% of you can. So hopefully this one is from 9 years ago. So hopefully the audio is fine for everybody. I can't tell because I can hear them all. So you guys are going to have to tell me if you can't hear. This is a lawyer getting in trouble. I love to see it. Yeah, Bill really likes her. She's awesome. All right, for once I can't hear. Okay, that one didn't work. Not to worry. Not to worry. I got a second one ready in case that happened. It's just a YouTube video. I don't understand. This next one isn't as long, though. It's going to be a short stream. If this one doesn't work, then then the stream is over. We'll start OJ early. This one I have to fast forward just a pinch.
Judith DeBerry
All
from
right,
the Commission
you should
Board.
hear that one fine, right?
Introduce the board. This is a reciprocal disciplinary action pursuant to Part 9 of the Texas Rules of Disciplinary Procedure based on the respondent, Ms. Garrett's professional misconduct and suspension in Minnesota. Petition for reciprocal discipline was filed with the board on August the 25th, 2015, and the first amended petition was filed on November the 24th, 2015. The order to show cause on the first amended petition for reciprocal discipline was issued by the board on November 30th, 2015, requiring the respondent to show cause within 30 days while reciprocal discipline should not be imposed in Texas. Respondent signed a waiver of citation on December the 8th, 2015, acknowledging receipt of the first amended petition for reciprocal discipline and the notice of hearing. Waiver was filed with the board on December the 10th, and respondent filed an answer on January the 5th, 2016. On November the 5th, 2014, findings of facts and conclusions of law and a recommendation for discipline was filed with the Supreme Court in the state of Minnesota in the matter is styled. In re petition for disciplinary action against Impadanishi Sayanaloli to Yari Garrett, a Minnesota attorney, registration number 342075, file number A14-0995. And on July 1st, 2015, an opinion was filed in the Supreme Court of the state of Minnesota in the same manner that states, respondent is indefinitely suspended from the practice of law and shall be ineligible to apply for reinstatement for a minimum of 120 days from the effective date of the suspension. The referee in the disciplinary proceedings concluded the respondent violated the following Minnesota rules of professional conduct. Rule 3.4C, Rule 8.4B, C, and D. By willfully disobeying a court mandate, by making false or misleading statements to a tribunal, and by being convicted of criminal contempt for willfully disobeying a court mandate. At this time, I have four exhibits I'd like to introduce. Exhibit 1 is a certified copy of the findings of facts and conclusions of law and the recommendation for discipline filed in the Supreme Court of the state of Minnesota. Exhibit 2 is a certified copy of the opinion of the Supreme Court of the state of Minnesota in the same matter. Exhibit 3 is a certified copy of the order denying the petition for rehearing in the Minnesota disciplinary matter. Exhibit 4 is the original certification certificate from Blake A. Hawthorne, clerk of the Supreme Court of Texas, dated January 8th, 2016, which indicates that the respondent is licensed and authorized to practice law in the state of Texas. May I approach?
Have you shown, you have any objection?
No, yeah.
Okay. They're admitted. The exhibits are admitted.
And I'm going to say this again and again and again and again and again and again and again. Even if you're a lawyer, get a lawyer.
As reciprocal discipline, the commission respectfully requests that a 120-day suspension of Ms. Garrett's license be imposed as reciprocal discipline. I believe.
Is the CDC asking for 120 days? Because I don't know how the Minnesota provision, it says 120 days, at which point she can ask for reinstatement.
Correct. And to my knowledge, she has not applied for reinstatement at this time. We do not have indefinite suspensions in Texas, which is the reason we're asking for the 120 days. It's a definite period. And I believe she's raised some affirmative defenses that I'll let her address, and then I'll respond to those.
Thank you.
One of the main reasons I'm asking that the state not impose reciprocal discipline is because the State Bar of Minnesota and Minnesota's Board of Professional Responsibility for Lawyers does not have the same checks and balances as this board for the State Bar of Texas. There's no statute of limitations, there's no appellate process, there's no option for jury trial, and there's no significant screening process for complaints as we have here. When such processes are not in place, what can happen is what happened to me. Those with power, whether it's politically connected prosecutors or judges or large firm lawyers are inoculated from discipline, while others, solo practitioners such as myself, are criminalized, stripped of their licenses, and face roadblocks designed to break them financially. The affirmative defenses that I present to the board are fourfold.
It's a conspiracy, guys. It's a conspiracy against small lawyers like her. They just get willy-nilly disbarred.
First, there was no actual proof to establish misconduct, and certainly not by preponderance of the evidence. And as you'll see in Exhibit A that I submitted with my answer and affirmative defenses, the entire transcript of the hearing that occurred. If you review that transcript, you'll see that the board did not actually present any evidence of misconduct.
Let me ask you, just for clarity, were you aware that it was perceived that you had been hospitalized and were impaired against showing up at a time when you actually were in Paris at your brother's wedding? Were you aware that that was the perception given to the court by your communications?
No, because that was not the perception given to the court. As soon as I got out of the hospital, I immediately contacted the court and told them that I was out of the hospital.
And that you could not come to court?
That I could not do a trial.
That it was too soon?
Yes.
And that's why I asked, don't you think there was a perception to the court that your impairment prevented your coming rather than your presence in Paris at your brother's wedding?
My impairment certainly prevented me from doing a felony trial for a woman facing significant time in court. It did not prevent me from sleeping on an airplane.
Right. And then where in the record, in the two transcripts that you attached or elsewhere, does it show that you furnished to the judge the information about the medical condition that you had been directed to furnish?
Yes. In fact, the judge ordered me to furnish proof that I was in the hospital by 10 a.m. on a Wednesday, and I did so. I furnished that to the court and to the judge. During the transcript of the hearings, the telephonic hearings, the judge said, well, that's just not enough. I repeatedly requested what else would the judge like other than the documents that I got from the hospital, and that was never stated nor clarified. Again, there was no actual proof of misconduct, or certainly not by preponderance of the evidence. The complaint that was levied against me was not by my client. It was by the prosecutor. It was a very contentious case, and the prosecutor filed that complaint as well as pursued the criminal charges against me, as well as testified at the criminal hearing. And at no point was my client even ever asked to testify at my board hearing. At no point was even the judge asked to come and testify. It was purely pursued and relied on by the prosecutor. And interestingly enough, that prosecutor himself, when asked about whether or not I misguided the court, the prosecutor stated, and I believe the quote was, it was unclear as to whether or not I did. And certainly that's not proof or evidence. Second affirmative defense that I present to the board is that it would be a continuance of a grave injustice to impose the discipline identical to that done in Minnesota. You'll see in Exhibit C, I listed a number of cases where attorneys were convicted of misdemeanors or gross misdemeanors or faced charges similar to the ones that I faced, and none of them, not one, received more than 30 days suspension. There was one particular case that that the Supreme Court of Minnesota relied on, where the charges were eerily similar to my charges. There were a few more charges that she actually had that I was not ultimately charged with. It was the Henry Michael case, and she received 30 days. And when that was brought up to the court said, well, the difference is that she wasn't criminally convicted. Well, that's not a difference, because what happened was we were charged with the exact same, we were in the exact same situation and charged with contempt of court. The only difference is the prosecutor actually charged me with the crime. The actual underlying facts are not very different. So the fact that I was actually charged with the crime should not be an impetus to give me even more punishment than in that case. There was another case in 2011, Henry Hoffman, where the gentleman was convicted of a gross misdemeanor. And at that point, the Minnesota Supreme Court said, well, he suffered enough. He went through the criminal justice system. He has a criminal record, and he paid enough by way of a fine that we're not going to impose any discipline on him. And so he was not disciplined at all. Third, with respect to my affirmative defenses, if any discipline is to be levied, the misconduct established would warrant substantially less discipline in Texas, and even in Minnesota, as I just stated, it would warrant substantially less disciplined. And again, that's detailed in Exhibit C with respect to the much less discipline that it would even warrant in the state of Minnesota. And four, there are certain of the allegations, specifically the criminal misdemeanor and the charge of conduct prejudicial to the administration of justice, which, as far as I can tell, does not constitute professional misconduct in Texas. With respect to the misdemeanor conviction, my understanding is that unless it's a felony or unless it's a misdemeanor involving theft or involving moral turpitude, the state of Texas does not automatically impose discipline for that, and neither of those was the case here.
That's the only reason I got this guy, because she said moral turpitude.
I want to go back to my first question to you. There was a finding, whether accurate or not, there was a finding that you failed to furnish any of the documentation that the judge directed you to furnish. And my question is, where in the record that you have brought in this case does it show that you unequivocally, without any contradiction in the evidence, furnished that?
If you review Exhibit B, which is the brief that my lawyer submitted.
That's a brief, right?
Yes, we actually reference different portions of the underlying record in that case, and we address that that very same matter that you're inquiring about here.
Show me where that is. In other words, you're saying that the finding by the Minnesota court is wrong and without any evidentiary basis.
Certainly not preponderance of the evidence. There certainly is not a preponderance of the evidence.
So help me find where you show conclusively that all of the information asked for by the judge was furnished.
And she never showed her medical documentation as they wanted. What she did was she provided a court transcript of where she showed a hospital release. I lost the word. We'll hear it later in a different hearing. So she just provided that testimony, that transcript of that hearing, that she provided paperwork during that hearing.
If you look at page 21,
thank you.
It discusses the district court proceedings, but there's another more specific issue, I believe. A more specific identification of the documents.
Page 21 says you showed some witnesses and so on. I'm not yet finding any I'm not yet finding the record contradicting the Minnesota courts.
NFL, NFL.
Is there a site to the transcript?
I believe that there's actually a site to one of the pieces of the documentary evidence that was brought in, not the transcript for the hearing, but the transcript for the actual hearing with the judge in 2011. So it should be a site to that.
Any other questions?
Oh, I'm sorry. Okay, so if you look at page 19.
Thanks.
And then if you look at the second paragraph, it says the referee's findings were clearly erroneous in concluding Garrett's statement concerning a follow-up medical appointment that week. The evidence does not support this finding. The fact that the follow-up appointment is proven from the hospital
Not when there's 4 minutes left on the clock. Then they don't.
discharge records admitted into evidence.
I
The
love
hospital
the
discharge
AFL.
records are
I
the
love.
evidence that were requested, and those were provided to the.
I think. Well, who was it? Doug Flutie was one of the first AFLs. Oh no, arena football. Remember arena football? I loved arena football. I loved it more than the NFL. And then it's gone that I can see. Or maybe it's just not popular anymore.
That doesn't show that they were.
Sorry. Do you know why they stand around a lot? It has nothing to do with football. Do you know why they run through 2 or 3 plays and then at the whole game just stops for a few minutes? And then you just stand around and wait. And then you start playing. Do you know why they do that? It's so they can play commercials. They wait. The professional football teams stop playing so that we can watch commercials. A lot of commercials. All right, I'm going to try to focus on court.
Provided the discharge records were provided in the evidentiary hearing. What is in this record to show that by 9 a.m. as ordered, information was put in the court's hands back in early May?
Right, so it references Exhibit 16, and Exhibit 16 was the actual transcript in the underlying case. So it shows that the discharge records were not submitted in this court, but actually in the underlying court in 2011. And we can get you a list of those exhibits.
Have you reapplied in Minnesota?
I have not. It's very expensive to reapply. They've fined me over $1,000. I don't know exactly how much it was, but no, I have not applied.
Do you understand that, at least the way I read the Minnesota order, it's 120 days and then you get to reapply, which could be indefinite. Whereas Mr. Berry is saying the CDC is only asking for a flat 120 days. Do you understand the difference between the two?
Yes, Mr.
So it seems to me that the penalty that they're asked for is significantly less than in Minnesota. Would you agree with that?
It is less, yes.
Thank you.
And it is also certain as opposed to indefinite.
Yes, the 120 days has passed. I believe the order came down last July. I just have chosen not to reapply.
There's only one sport, really. Only one sport worth watching. And that's Cooper's Hill cheese rolling. That's the only sport worth taking the time out of your day to watch.
And as long as you don't reapply, that suspension is in order, correct?
That is correct.
Okay. Any other questions in the panel? Thank you very much.
Thank you.
Board. I'd like to respond to some of Ms. Garrett's arguments. I don't believe there was an infirmity of proof. There's actually quite a bit of evidence in the record and testimony. It's one of the things she was asked to provide that she never provided on the 3rd was an affidavit from the medical facility from the doctor, which included her prognosis and when she would be able to continue. And I think it's important to note that the email that she sent, and I'm going to read it, was very specific and clearly intended to mislead. I have just been released from the hospital and will definitely not be able to attend a scheduled hearing this Thursday, May 5th, too soon. Taken together under the circumstances, that's clearly misleading. And comment 2 to Rule 3.03 indicates that in many circumstances, an omission is the equivalent of an affirmative representation, as it was in this case.
When did she fly to Paris?
She flew on the 4th. So she actually flew through Minneapolis on the 4th, which is where the court was being held on the 2nd and 3rd and on the 5th. So she was actually in Minneapolis in the courtroom, and they had videotape from the airport showing.
What about her argument that the procedures in Texas?
They went to the airport and got videotape of her getting on a plane to Paris when she said that she was too sick to get to court.
Texas are different than Minnesota. That is that she doesn't get an appeal. Do you consider the referee finding and then the appeal from there to be such an appeal?
I think that's a two-step process. The process in many states is different. I think she also had the ability, and she did ask for a rehearing, which in many states is the equivalent of an appeal, and that was denied. And specifically in that they found some of her pleadings were frivolous.
But she didn't have the opportunity to appeal to an
She's a lawyer, and they found her filings frivolous.
appellate body such as we are. Is that
Because
correct?
because their disciplinary proceeding, and as in many states, the Supreme Court is the one that makes that final decision.
Has the due process issue been raised as to the Minnesota system and found to be that it meets the due process standards, or is this just no law
I have
on
not
that?
seen any authority that says that it doesn't meet the due process standard. She did not raise that in her pleadings, so I really didn't look carefully into that issue.
So one thing both of these lawyers are saying, which is interesting. The other lawyer is saying that it is her burden to prove that she committed a crime. So not charge her with a crime or anything, but if you're going to discipline her for being a criminal, you have to prove that she committed a crime. I mean, in my head, that sounds right, because in America, you're innocent until proven guilty. Except she says, no, the burden is on her to prove that she did not commit a crime, or she can just take the suspension. And all this is not for disbarment. This is for 120 days suspension. That's all she's looking at. Now, I don't know about her Minnesota license. She said she can't reapply for that because it's $1,000. And that's way too expensive for her. She's a lawyer. A lawyer, robs people. Anyway.
Issue. That was not one of the things she raised until today. As far as a grave injustice, her argument doesn't even touch on what it is in Texas. It's basically that she, for some reason, feels she was discriminated against in the proceedings in Minnesota. And then she goes into the sanction that was imposed. And I would refer the board to look at the elements and the aggravating factors that the referee or their hearing officer listed that he considered when imposing sanctions. And many of those are the same as we have in our Rule 2.18 and 3.10, which are the factors that evidentiary panels and courts consider when imposing sanctions. And those included the nature of the misconduct, and he specifically found that her actions were intentional. Her conduct during the proceedings, including making further misrepresentation during the disciplinary proceedings. The profit to the lawyer, in this case, her self-serving motive to go to Paris. The loss or damage to her client, that's speculative, but obviously to the client, to the court, the administration of justice was delayed because they couldn't move forward with the trial.
Ms. DeBerry, the standard is we have to honor the Minnesota determination with a few exceptions. This is an exception. What is the burden of proof and who is it on with respect to grave injustice?
It's her burden of proof to prove the affirmative defenses and in any of the defenses that she raised. And I don't think she's met that burden.
Nursing.
Another thing that the court found was that she failed to recognize the wrongfulness of her conduct, and there was no showing that future clients, that this misconduct wouldn't occur in the future. Significantly, the court found no mitigating factors in the disciplinary proceedings against her. I've looked at similar cases in Texas, and while I can't find one that's exact, I've seen a range in the published cases from, I think the low end was 18 months, partially probated with 3 months active, all the way up to disbarment. Now, the underlying facts in some of those and that was just an 8.04A3 rule violation for dishonesty, fraud, deceit, were different in a lot of those, which account for the range of sanctions. Her argument that
I just want you to know, Maiko, that you just put the fear of God into me for a second. That would be a nightmare. And you just scared me so bad that I'm not going to be able to sleep for a couple of days.
the misconduct is not, or the rules are not the same, is misplaced, because all the Texas rules require for reciprocal discipline is that her conduct in Minnesota would constitute misconduct here. And it absolutely would. 3 of the 4 rules are, if not identical, substantially similar to the Minnesota rules. She makes the argument that the 8.04, our 8.04A2 requires that a misdemeanor doesn't qualify. However, if you read that provision carefully, it's a disjunctive provision, and it's a serious crime or any other crime that reflects adversely on the attorney's honesty, truthfulness, or fitness to practice law. And the fact that her criminal contempt charge, although it is a misdemeanor, was directly related to her practice of law, I think does reflect this on her ability, or her truthfulness and honesty and fitness to practice law. The other rule, the final rule, is significantly different. I don't think we need to reach the argument on interfering with the administration of justice versus obstruction of justice, because we've already established that 3 of the rules are essentially the same, and it does constitute misconduct in Texas.
Any questions? Anybody? Thank you very much.
Thank you very much.
We'll take.
Okay. First, we're going to go on a tiny field trip, and then I'm going to tell you what I know about that lawyer now, today. This is the only sport there is. There they all are. Look at these athletes. Look at them. They're ready. He has a helmet on. Kick him out of there. He has a GoPro on. That is very, very, very smart. And here we go.
Ask you, mate. What's your name? Sorry.
All right.
Lewis Alex.
That was it. That was the cheese roll. They throw cheese on a hill, and then you have to run down and beat the cheese to the bottom of the hill, and everybody falls. And everybody falls into each other. and it's awesome to watch. I would never do it, but I feel like if I did it, I would not fall down. I feel like I could run down the hill without falling down. That's just how I feel. But I'm never going to try it. So, about that attorney who really, really should have gotten an attorney. She is practicing law in Texas right now. So she is fully, see, that's green. That means that she's, whatever happened is over, well over with. Get down right now. Get down. Get down, please. So I was recording and I couldn't take my earbuds out of the computer while I was recording because there would be no sound in my videos if I didn't have them in there. So I thought maybe the cats would not hurt them. No, they did. They ruined my last set of earbuds. So I have Reese's peanut butter cup. I can't even show you. I have Reese's peanut butter cup earbuds, but they're so freaking tiny. I have to stay way over here. I hate these cats so much. I hate them. All right. You know what? It's just not time to stop yet. It's just not. Let's just watch. I want to do the one with the polka dotted tie. So. I appoint the public defender. Here we go again.
Using if you were using.
Yeah. I haven't had time to look through these yet. I know I clicked through them with you guys, but I haven't actually had time to look through them. I'm looking for the polka dotted. This one?
You won't consider an RR?
We saw him. Don't worry. We saw him. Oh my gosh. I know he's around here somewhere. He has 2 ties. We're looking for the polka dotted one, and we'll just watch him for a couple of minutes.
Right on the edge
20 or 30 minutes.
This is the.
All right, we're back to May 9th. Come on, where are you, Eric? Eric. I don't like that court at all. I don't know why I recorded it. I hate that court. Oh, I love him. You know what? No, let's see him. Oh, Judge, you are so mean to me. It's so hard to get him because he rarely ever goes live and there's no like notification. I have to stumble on him by accident. So I recorded him for 22 hours and nothing. He didn't go live once during that time. Jacob. There it is. Oh, that's not polka dot, but it's good enough.
All right, bond continues on 16th at 8:30.
Thank you, Your Honor. Could I briefly call pro se matter number 7, Anthony Aragon? Just get him out of here.
I just can't, Kelly. I absolutely cannot. So, look, starting right now, we have absolutely got to be on our best behavior in this chat because I'm pretty sure I was shadow banned. And now I have to dig myself out of it, which means my stream, my channel is not being shown to anybody. You guys see it because I posted in Discord, but YouTube is not suggesting it to anybody. It's not showing up on anybody's feed for any reason. So I have to dig myself out of this shadow ban, and it's going to take a couple months. But during that time, we got to behave. We can't break any of their rules, even though we don't really know what all the rules are. Because literally, if it stays the way it is right now, it's not worth it. I mean, I'm putting many hours of work a day in for this, for like $200 a month. And that's not sustainable. So we really have to not do anything. When you say you see it, so like when you click the home button, it shows up in your list of videos. When you click home, it shows up as like a recommended video. If you're not subscribed, if you are not a subscriber at all, you'll never see it. They stopped. If you look at you can see, I can see in my analytics the day it happened, the day I was shadow banned. One of the reasons it happened was because I never used to monetize live streams. I would, leave the commercials off. YouTube hates that. And now I can't show up in anybody's recommended. And also, they've unsubscribed people from my channel. Not as bad as I've seen them do other people. I'll give them that. But enough. So when you, yes. So that's another thing. They say don't schedule lives, but I'm still going to do that. That's why we have to be really careful with what we say. We can't talk about drugs or alcohol or murder or shit, damn, hell. We can't do any of that anymore. Just until it's back to normal again. But yep, always. I'm going to fight through it. I'm going to take the 3 months and try to fix it. I love doing this. So I don't want to stop, but we don't want new friends. Me neither. It's a private club. But what if there's a second Chinny out there? Yeah, I said, but after today, it's like right before you go on a diet, you go eat a whole pizza. All right, after this pizza, we can't eat any more pizza. After this cigarette, we can't smoke anymore. After this drink, no, wait, never mind. I'm not going that far. DJ, that's funny because I have a friend that lives in Australia, and you and her are twinsies. And her name is Carolyn as well. Carolyn Black. Do you know her? She's Carolyn Black. She lives in Australia. So you should know her because you live in Australia. Anyway, I can't remember her husband's name. That's all right. It doesn't matter. It doesn't matter. But yeah, you should meet her someday. That's good. That's good. But no one else sees me. No one who's never seen me before. They don't get to see me. My impressions don't go to anybody else. It's bad. I mean, it's really bad. So here we go. Let's get back to Eric because I really love this judge. I mean, favorites of all time, and he is there. He will always be there. Yes, he thinks a lot. I told you, Australia. All right.
Any questions? Sure.
All right, we should try to figure out what his name is. I don't know how we're going to.
Yeah.
But I want to know his name right there. Oh, and by the way, if you love this judge, which you will if you watch him, you can only see him here. Nobody else can show him.
I'm on a computer.
Okay, CJ. I got your back. CJ. Hold on. Bam. Bam. No, not him. This guy. Oops. How did I pause it? His coordinator or clerk. This guy right here. What is his name? This is Eric Johnson. And he's already thinking hard about this case. We gotta love that.
The internet is slow. Twenty-five CR 1820, People versus Anthony Aragon. Mr. DeCecco for the prosecution. Mr. Aragon is present in court.
Colorado.
Without an attorney.
Denver,
And
Colorado.
Judge, Mr. Aragon just got the application for the public defender's office. He's going to turn that in before the next court date.
We'll do better than that. You're going to get that turned in today. Yes,
So, Your Honor, he has started the application. I think that we just need some supplemental documentation regarding his income.
He'll get that to the public defender then by Friday.
Yeah, actually, I can get that done for you today.
Excellent. My order is by Friday. You get it done today, then you got 4 days to relax.
Perfect.
And then this is the case where I filed a motion to amend count 1. I'd ask for it to be remanded back to 3G for PH.
That seems worthless if he's not going to have an attorney yet.
I don't know if we can set.
We also have the motion for non-testimonial identification.
And I provided him a copy of that as well.
Which we will grant that. It's in the division inbox. All right, let's set it for, we do the 19th in the afternoon.
I love this judge the best when there's a plea deal. So he's just resetting. So I'm going to fast forward through this because nothing's happening. All right, here's a new one. Let's see if he's taking a plea. That's where the gold man is right here somewhere or right here somewhere. Someone just move the camera. Don't worry. They'll move it back. They always do. It's there. It's not there. It's there. It's not there.
I told you I would.
Is it just me or is the bailiff standing kind of close to this guy?
All right, 19, 20, and 21. All People versus Farmer, 22 CR 3443, 22 CR 6108, 23 CR 6605. Entries?
Daniel DeCecco for the People.
And Maddie Curry from the Public Defender's Office on behalf of Mr. Farmer, who appears in person in custody to my right.
All right, we are here for sentencing.
Yes, Your Honor.
Proceed.
Defenses, yes.
People are ready.
Oh, resentencing. I think that means that he broke the law again. And now he has to be resentenced.
Go ahead, Mr. DeCecco.
Your Honor, in these cases, or at least in the 2 drug cases, the people had previously asked for community corrections. The court was willing to give him a shot on probation. He squandered that opportunity. He continued to abuse substances and pled guilty to a violation of a protection order. I would ask the court to impose community corrections in both 22 CR matters and a consecutive jail sentence in the 23 CR case. Court would also be justified in sending him right to prison, but I think he could benefit from the services within ComCore.
Scurry.
Thank you, Judge. The court found a violation of Mr. Farmer's probation when he took accountability in his new law violation and ultimately pled guilty there. I think it is important to note for the court that Mr. Farmer was complying with some of the terms of his probation. In reviewing the file, it looks like he was engaging in treatment in his classes, but unfortunately looks like he had a relapse in August and July with regard to his alcohol addiction. Mr. Farmer previously before that had been sober and was doing well in the community, and was engaging with the services that probation offered. In speaking with Mr. Farmer, we are also, I guess, jointly asking for the court to consider a sentence to community corrections in this place, or in this case. Mr. Farmer would benefit from the increased structure that community corrections has to offer, while maintaining his employment. Before he was arrested in this case, he was working at King Soopers warehouse, and had been working there for about 7 months. It's my understanding that he has a child on the way and a one-year-old who's turning 2 in August. Should the court consider community corrections and should he be released? I'm not sure the exact details of this, but he does have employment lined up for him through his uncle working in the oil fields. I'm not sure if that would work out with ComCorp, but he is demonstrating that he's being proactive with trying to reconnect with positive resources in the community, and ultimately wants to be able to provide for his family. Your Honor, in speaking with Mr. Farmer, it seems that he just wants an opportunity to be out to provide for his family. He has taken accountability for the main allegation in the complaint here. And so we would ask that the court grant community corrections in these cases. And we would ask for the court to allow his jail sentence in 23 CR 6605 to be served in community corrections as well. We would ask for the lowest amount the court would consider. I believe 4 years would be the lowest on these cases. And so that's what defense would be asking for today.
I just don't think there's any way this judge is giving him community corrections. I just don't think so.
And Your Honor, I have pre-sentence confinement credit calculated if the court would like me to put that on the record now.
That is damn near what I think the judge is going to say to him. I mean, you almost took the words right out of his mouth. I think. I don't know.
Yes.
I calculate 323 days total.
323?
Yes, Your Honor.
That can't be on all cases.
I believe.
There was a difference of like 12 days.
Oh, in each of the matters. I apologize. Okay, so that's pre-sentence confinement credit in 22 CR 3443. And if
So
the
12
court,
days fewer.
yes, I believe so.
Sir, you have the right to tell me anything you'd like me to know before I sentence?
I got a baby on the way, and I understand I messed up to be in this position that I am now, but I want to do everything to make it right and be there for my kids. I can't say too much. I messed up, and I'm trying to take accountability for it. So if I can just get a chance to do that, to make it right, I'll do anything, really.
You've got 2 drug cases and then
I can't change the numbers.
An
I
assault
can't.
case. Look, being a father can be great. Your kid doesn't need you on drugs. You're not going to be helping that child if you're on drugs. You're going to be doing harm. I hope you get it together. But I'll give you a chance at community corrections. But if you violate it, you're just going to prison, and don't ask me to consider your kid. If you don't care enough about your kid, do not ask me to care about your child.
Sir.
23 CR 6605 is a class 1 misdemeanor. I'm going to sentence you to 364 days in the county jail. I'm going to give you credit for the 311 that you have already served. And 22 CR 6108. I'm going to sentence you to 12 months community corrections. It's going to be consecutive to the 23 CR 6605. We'll note the 311 days. And 22 CR 3443 will sentence you to 4 years community corrections. That is consecutive to the 23 CR 6605. But that is concurrent with 22 CR 6108. It's concurrent while you're in community corrections. You walk away from ComCore, you pick up a new charge or anything like that. And when you come back, we're going to have a sentencing hearing. And I will strongly consider whether or not to run any remaining sentences consecutive.
Sir.
We'll note the 323 days.
And Your Honor, I apologize. I do have the updated calculations. It wasn't as straightforward as I thought, but in 22 CR 6108, I actually calculate 415. Probation calculated 297 days of pre-plea confinement credit, and then he accrued an additional 118 days during the pendency of his new law violations for that 415.
All right, so in 23 CR 6605, it's still 311.
That one's 397, but given that the court is sentencing him to 365, I do believe that is.
All right, well, we'll still note the 397.
Yes.
The 22 CRs.
I'm going to go with yes, Michael. If you spend a year in jail and then found not guilty, do you get to go back in time? I'm going to say yes, Michael. And do you want to know why I'm going to say yes? Because he looks like he would make a fantastic doctor. So he has a TARDIS, and he'll just take him right back.
6108 will note the 415 days. And then still the 323 and 3443.
Yes.
All right, good luck to you, sir.
Thank you.
Thank you.
Yo, I am floored that man got community corrections. The judge must have had a really good night last night because the judge doesn't do that. Although he knows that it's gonna be worse for him in the long run. So what just happened is gonna be really, 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 really bad for this guy, because if he messes up, everything is going to be revoked and it's going to be concurrent. All cases will be concurrent with each other. And this judge will do that. He does it all the time. All right. Let's see if we can get another a plea offer real quick.
All right, we think we're ready.
Think so, Judge.
Measure twice, cut once.
Men say that when they're building houses too. Okay, nothing he does is quick. Nothing. But that's because, okay, when you first started seeing me, I had to cut my hair real short for a medical reason. I had to cut my hair so that it went to my shoulders because I work in a restaurant. So if your hair goes below your shoulders, you have to put it up in a ponytail. And I was not able to put it up in a ponytail because I had a red patch on the back of my neck. But it's gone now. That red patch is gone, so I can let my hair grow again. Another thing was, before Fozzie sent me this camera, and for the last 8 years, my hair's black. It's always been black. I love my black hair. I always have black hair. But what happened was, COVID hit. I stopped coloring my hair, because who cared? We all just had to stay in the house anyway, you know? And since then I started working from home. And since I was working from home, it really didn't matter if I colored my hair or not. So the black, grew out. And then I was left with my brown gray hair, a lot of, gray. And right before I got this stupid camera, my mother had got me, she found this red dye, like 4 or 5 boxes of this red dye at a garage sale, for like $3. And I'm like, bet. Yeah, I'll use that. And then I think I went on a date or something. I dyed my hair because I was going out on a date with this guy. And I think he was a no-show. I think I dyed my hair and he didn't show up at all. And didn't text me, nothing. It was fine. I still had to date with myself. I entertained myself. I did me better than anybody could do me on that day. So, and then Fozzie sent me this camera and my hair was red. And then I thought, well, I'm about to say a bad word, but I won't. Blank. I guess I have to keep it red now because people are looking at me and they see my hair is red. So, but I just want my black hair back so bad, but I'm going to leave it like this because everybody's used to this. But I really liked my black hair. It happens all the time, Donald.
Now I can't tell which Rule 11 is the right one in 4897.
In 4897, both Rule 11s should be the same. It's only the motion to dismiss that changed.
All right, the motion to dismiss count 1 because he's pleading to count 2.
Correct.
We got a celebrity in the house, guys. King of YouTube. That's what Bill is. King of YouTube. Thanks for Judge Boyd today and Judge Wolf. That was great. I enjoyed that.
All right, so the paperwork then in 24 CR 4626 is for Mr. Johnson to plead guilty to a class 1 misdemeanor, drug misdemeanor. And in 24 CR 4897, pleading guilty to a drug felony 3. With a divert screen.
Yes, Judge.
Correct.
I'm going to post the link to something all right, I'm just going to post what I see in my browser, not the whole link, because that'll just mess you all up. But what I see in my browser right now for
Is that your
StreamYard,
understanding of what you're doing, sir? The other cases are going to be dismissed.
Yes, sir.
Yes, sir.
There's also a plea in 1700 with DF4,
Oh,
and we submitted corrected.
doesn't that look like my browser is telling me to go to the pub? That is for 2 hours and 1 minute. I've been seeing that, and it's been telling me to go to the pub, go to the pub, go to the pub. Oh, I gotta set up OJ.
Elements and Rule 11 on that.
I also need to call 25 CR 1700.
Sorry, that was the add-on.
Now again, I have to figure out which one's the right one. Was this the one with the DF4 issue?
Yes.
Yes. And the paperwork submitted at 10:24 should be the
Yeah,
correct.
until it's accepted, it's not time stamped. All right, I think I've got it.
Got it?
More than 4 grams.
Yep, the schedule 1 or 2, yes.
All right, then also then, Mr. Johnson. Pardon me. I guess in the 25 CR 1700, you're pleading guilty to a DF4, count 3. That's presumptive range?
Yes, Your Honor.
All right, counsel, wait for their advice on Rule 5?
Yes, Judge. On all 3 cases.
Yeah, I think I did recall them. Oh, wait a minute. No, I haven't gone back on the record.
All right, no, we're not gonna say anything
All
bad.
right,
about
24
any
CR
other channel.
4897, the 25 CR 1700, and 24 CR 4626. People versus Freddie Johnson. Mr. Walton for the prosecution, Mr. Adine for Mr. Johnson, who is present in court in custody. Mr. Adine is waived reading an advisal under Rule 5. Mr. Johnson, how old are you, sir?
47,
And how far have you gotten in school?
GED and vocational classes.
Excellent. So I presume then that you read, speak, and understand English?
Yes, sir.
Are you a veteran of the United States military?
No, sir.
Under the influence of any drugs, alcohol, medications, anything that would be affecting your judgment today?
No, sir.
Counsel, are you in compliance with your obligations under Bozo and Padilla?
Yes, Judge.
All right, sir, in 24 CR 4626, the drug misdemeanor 1, I understand you wish to plead guilty to unlawful possession of a controlled substance. That count reads that on August 4th, 2024, you did unlawfully and knowingly possess a material, compound, mixture, or preparation that weighed not more than 1 gram and contained any amount of fentanyl. Is that the right one? No, that's not 1 to 4, so. All right, to that count, do you plead guilty or not guilty?
Guilty.
In 24 CR 4897, you want to plead guilty to a drug felony 3, possession with the intent to distribute fentanyl. On or about August 16th, 2024, you did unlawfully, feloniously, and knowingly possess with the intent to sell an analog of fentanyl, carfentanil, or benzi. You guys did this on purpose, didn't you? Benzimidazole opiate. To that count, do you plead guilty or not guilty?
Good
Guilty,
job,
guilty,
Eric.
sir.
All right, then finally, in 25 CR 1700, a drug felony 4, on March 27th, 2025, you did unlawfully, feloniously, and knowingly possess a material, compound, mixture, or preparation that contained more than 4 grams of a controlled 1 or 2 controlled substance. To that count, do you plead guilty or not guilty?
Guilty.
All right, before I accept that plea, let's make sure that you understand a couple of things. First, a drug felony 4 carries a potential sentence of 6 to 12 months in the Department of Corrections with a 1-year period of mandatory parole.
He's not
You
getting
understand that?
POC.
Yes,
No
yes,
way.
sir.
Oh, Zach, that's so scary. Sometimes
All
it
right,
takes
the
hours
drug
to get through
felony 3
TSA.
carries potential sentence to the Department of Corrections of 2 to 4 years with a 1-year period of mandatory parole. Do you understand that?
Yes, sir. Sir.
Hey, another Smith.
And then finally, again, the drug misdemeanor 1 carries a maximum sentence of 180 days in the county jail. Do you understand that?
Yes, sir.
All right, there are 2 cases, 24 CR 4193 and 25.
Yo, why would you say that in my chat? Remember, we just had a talk about this. And even though I already messed up, that doesn't count. We can't say anything bad in my chat anymore. I'm trying very, very, very hard to get out of my shadow ban situation.
CR 51, which will be dismissed. We'll go ahead and dismiss those. Part of the plea. All right, does he have the paperwork there in front of him?
He does.
All right, so in each of these cases, these requests to plead guilty forms are have been filled out and uploaded to the court. I'm looking at the 4897 since that's the
Remember back when I said we were going to do
DF3.
another plea real quick? Good times. And I was delusional.
On each of these Rule 11s, are those your initials next to each numbered paragraph?
Yes, sir.
Does that mean you went through this line by line with your attorney?
Yes, sir.
And if you had any questions, did he answer them for you?
Yes, sir.
Do you have any questions for me about anything that's in that document?
No, sir.
All right, main thing I want to call your attention to, again, I'm looking at the 24 CR 4897 on page 2. There is a paragraph 5. It's got lettered paragraphs A through K. These are all the rights that you have. Your right to be presumed innocent.
Oh, hell no.
Your right to trials, etc.
Oh, heck no. This is really hard, guys. I'm not going through all these A through Z rules.
Observed Mr. Johnson conduct a hand-to-hand drug transaction. They moved in and arrested him and located 0.174 grams of fentanyl and 0.278 grams of fluorofentanyl on his person.
Is that what happened in that case, sir?
Yes, sir.
In 25 CR 1700 on March 27th, 2025, Mr. Johnson sold fentanyl to an undercover DPD officer. On arrest, 5.1 grams of fentanyl were found on his person.
Is that what happened in that case, sir?
Yes, sir.
All right, well, understanding the rights you're giving up in each of these cases, understanding the potential sentences, do you still want to do this today?
Yes, sir.
All right, then I'll accept your plea, finding you've entered into it knowingly, intelligently, and voluntarily. I think we need to order, I always forget, I think they just want the ASR. Do we have the, oh no, they prefer a PSI. So we need to order a PSI. Do we have the release of information? We have that? Excellent. All right, then, in each case, bonds will be revoked pending sentencing. And we will set sentencing for June.
Every day they get a list from probation of when they're, how long it'll take for the report, so that's what he usually looks at it.
I'm just leaving the leaderboard up for the end of the video.
At a minimum. Plus, we gotta make sure.
If you notice, first place is really tied.
All right,
Wow,
let's do June 16th.
I can accept that.
All right, we'll do sentencing at 8:30 on June 16th. Yeah, full PSI is what they prefer.
Hey, where did
Yeah,
Nicole
go
go?
ahead and dismiss the other two cases now.
Nicole's gone.
Pardon me. All right, that'll conclude these matters. We'll see you
She
back
got
then.
25
I'll
XP.
set up the bird screen. I just want to make sure we got that through.
Yeah, we've noted it. We'll email the problem solving coordinator. And we should be good to go.
Thanks, Judge.
All right, do you have any other cases, Mr. Hedin?
I do. I have Mr. Trujillo. Good luck. I have Mr. Trujillo. Mr. Kellen is.
No, you don't. No, you don't, sir. No, you don't. Okay. Thanks to our leaders. It says, Donald, it says you're number one because you had the last comment. But you, CJ, and Monica, and Kelly all had 225 XP. Who knows? Another Smith. Who knows? Oh, look. It's fine. And then so close behind Chris, Nan, and Maiko. Look at that. The rest of you know exactly where you are. I'm going to go down to the bottom. There's Nicole. I just looked. She wasn't there. And now she's there again. Thank you, Nicole. BI, where are you? There you are. 75 XP. Let's go. Let's go. Thank you so much for commenting. That helps. Ugh. If you want to, please hit the like button and make sure that you are subscribed and you didn't get unsubscribed, desubscribed, non-subscribed by YouTube. Happens sometimes. Oops, I forgot to do this. Oops. Well, I don't know where it went, so I'm going to try to. No, absolutely not. No, I don't think anything in the world takes as much as YouTube. Most of you will be popped over to OJ. PayPal takes almost nothing. I think Venmo takes almost nothing. Cash App takes almost nothing. But Patreon and YouTube, and they take a huge chunk. But it's fine. It's still better than a stick in the eye. You know what I mean? What is, today is, somebody help me. What is today? Thursday. Today is Thursday, so I will see you all tomorrow. Thank you so much for coming out today. I really, really, really appreciate it. I mean, I definitely don't do this for the money. I do this for you guys. So when you show up, it's awesome, and I appreciate it. I will see you all again very, very soon. Bye, guys. Oh, look, an outro.
Got these lights that goes digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's life.